This is the matter of Poggemoeller versus Poggemoeller, case number 24-11258 DM. Present in the virtual courtroom, we have both parties. We also have Mr. Krupp representing Mr. Poggemoeller and Ms. Wolfram representing Ms. Poggemoeller. We are here on the plaintiff's motion to show cause against the defendant. And Mr. Krupp, I have read your motion.
Thank you, Your Honor. And Your Honor, there's a couple different issues that we need to address. Obviously, in my client's opinion, we're getting passive aggressive. Oh, we'll do FaceTime, but then the children will point the camera towards the wall. They're not participating, and quite frankly, it's being initiated, in our opinion, by the defendant, encouraging the children to be passive aggressive. You know, try to participate enough so I have a cover story, so to speak. But in all reality, I'm not going to have these kids participate. There's just been a ton of alienation, and we were hoping that we could get through this. My client said, you know, after about a month, hopefully she can get over the alienation and we can stop this and we can start being adults. It's not improving. She's telling the children to object to stuff, pointing the camera towards the wall, etc. She's not facilitating or encouraging the parenting time. She's actually encouraging them to not participate. It's been absolutely miserable, and he's trying to do his best to be cooperative with her and try to be the bigger person. It just hasn't been working very well. So the court has to, I think, step in and have to order her that she has to have the children actually be on the camera. They have to participate. They have to meaningfully participate. And she has to get the children involved. It's not, I think opposing counsel's argument is going to be, well, she puts them in the room with a camera and then she leaves, and then they turn around and they're doing all this stuff. Well, they're doing this stuff because mom is encouraging it and is not doing what she needs to do on her end, and stop the alienation. So
Remind me how old they are.
There's a range, Your Honor, everywhere from top end is 16 down to 5. So a big range of children.
Okay.
So, and my client's doing his best to try to, you know, and mind you, we let her move to Chicago because she thought that would help her transition into getting a job and doing a bunch of things. That's a problem. We did want to change the parenting time from 7 Friday to 7 at night on Sunday because of Chicago traffic. Right now it's 6 to 6. We want to change the order to provide for an hour different because my client has to drive to Chicago every other weekend to see his children rather than them coming here. Just financially doesn't work. So that was one thing, was changing the times, which I can't imagine would be an objection. Also, in April, we discussed enrolling the children in school for the fall because they need to, quite frankly, get socialized. They haven't been tested. My client thinks the 16-year-old may be on the spectrum. They're being homeschooled, and we don't even know where they're standing as far as academics. Their oldest, I don't think, is even the 18-year-old never graduated from high school. I don't think she actually got a degree, or did she?
Not that I'm aware of.
Yeah, I mean, at this point, the oldest, I don't think ever graduated from high school, never got a degree, nothing. She's 18. The homeschooling, this range of children is just not realistic. The children need to actually go to school and actually be in a setting where they can actually be tested and actually get some decent education. Right now, it's just, we're having a big party at home and nothing's getting done. And we brought this up in April. Oh, well, we'll look into rolling them this fall. Now it's, oh, we're not going to roll them this fall. We're not going to test them. We're just going to continue business as usual. I'm going to sit at home trying to homeschool a bunch of children when really she's not homeschooling them at all. They're just not going to school. So that's the classic thing. So we need to have them tested. We need to have them enrolled in school, that kind of thing. And we brought that up in April. So this isn't really anything new per se. And also there's an issue with getting copies of medical records. I did speak with Ms. Wolfram. She seems to indicate that if my client is given a password to the children's my chart, that somehow it would result in him being able to see her information. He doesn't care at all about seeing her information, but she needs to cooperate as far as getting my chart set up so he can actually see what's going on with his children. Quite frankly, he regrets at this point letting her move to Chicago because it really, everything that was supposed to be accomplished with her moving to Chicago, we've gone 4 steps backwards. And so that's where we're at, Your Honor. There's a show cause. She needs to meaningfully facilitate parenting time, not I'm gonna stick them in a room and then point the camera towards the wall and then they run around and refuse to even discuss or talk to him or interact with him as part of her alienation game. We need to change the parenting schedule from 7 p.m. on Friday to 7 p.m. on Sunday. She needs to fully provide us with medical information and access to the medical records. And we need to have the children enrolled in school. The thought that we're going to continue homeschooling, I mean, if there's the children are failing, and they need to be tested, and that's where we're at. I thought that things would calm down. Unfortunately, they just seem to not be calming down with this case.
All right, thank you. Ms. Wolfram.
I guess I would agree that I hoped things would calm down on the case and they aren't. But that was from the other side. Your Honor, as to the parenting time, I've instructed my client that she should not interfere with parenting time. So she leaves her well-capable 16-year-olds down to even a 5-year-old who can manage these devices in a room for them to have private parenting time with dad so that she's not interfering. My client is encouraging a relationship with dad, but it was strained for reasons of his own making prior to them leaving. And he has voluntarily failed to exercise parenting time for several of his weekends. My last recollection of talking to my client, it was more than a month that he could have had in-person parenting time, and he chose not to. She volunteered to switch weekends with him. She even gave up Mother's Day back in May, saying like, yes, it's assigned to me for the holiday, but it's a weekend that would normally be yours. You can have it. He didn't come. So the fact that there's a complaint about the Zoom parenting time that my client is somehow interfering is I mean, I'm fascinated how Mr. Krupp even knows any of these things, or how, his client has provided him the information about what my client is allegedly doing and saying without any knowledge of that, because the FaceTime calls have happened, they've occurred. The complaint is that they are not satisfactory to some reason, but my client reports that they go on for hours. Like, we're talking that, like, again, down to a 5-year-old are listening to books and things that dad is reading, but they go on and on and on. We're talking multiple hours, not like a check-in call, not like a engaging, how are you doing, but like hours long of listen to dad do what he wants on the Zoom call. And if you don't sit in front of the camera, then we're not happy with it. My client's doing her best to encourage it, but it's a difficult, version on that side, especially because she's not in the room. So she doesn't know what's happening on the call, other than their children are reporting that dad's reading these stories to them. So I guess for whatever it's worth, I think that we could work on what a relationship looks like and what Zoom calls look like, but I think their violation is without merit, because the calls are happening. And, frankly, forcing a child to engage on a Zoom call is just probably beyond the scope of not only the court, but frankly, my client as well. So as for the Zoom calls, I guess I would say that my client is not in violation of those. Secondly, with regards to this school, these children were homeschooled by my client by agreement between the parties. So this would be a change in asking for the children to be enrolled, and I think has to be done at an evidentiary hearing. If there's a request for testing, I haven't received it, so I don't really know what the testing is even about. But if it's about school enrollment, I've been provided no information about where the children should be enrolled or anything other than they should just choose a public school. There's tons in Chicago. So I think we need more information about that, and it has to be done at an evidentiary hearing. And lastly, is accurate. That's this health system, like the health system in West Michigan, Chicago, they're all the same. Everyone gets an individual login. My understanding after talking to Mr. Krupp is he wants my client's login, which I've informed him does grant access. Like, he's talking, give her the password, or give him her password and her login information. That's not how this works. A parent gets their own login and then can associate with their child's account. That's perfectly fine. If he provided some information that my client was preventing that, which she's not, I'd be happy to help facilitate it. I told Mr. Krupp I used to work in healthcare, so I have some familiarity. I'm happy to help facilitate it, but I'm not simply going to have my client give her password over, because that does reveal her health information, because that's how the system is structured. Not to mention that when it comes to children who are over the age of 12, all health systems, as far as I'm aware, make the association with a parent's account the choice of the child. So the child actually has to consent to it. It personally happened to me when my child turned 12. So I'm aware this happens, but in further research, that is the way it goes. Children over 12 federally have the ability to limit access to their parents. So if those are issues, we can bring those, but as far as I know, he's not even attempted to do that yet. So I've instructed my client to provide all of the healthcare information, doctors, appointments, all of that kind of stuff. If there's any, she can probably testify to the amount of information she's passed over, but I know it's substantial. So when he doesn't do his part of it, this court can't punish my client for it. So that's what I can say to that. I guess the last thing I'll say is that my client is willing, and I'm certainly willing to help facilitate resolutions. But Mr. Poggemoeller filed, I don't know, 14 violations in the front of the court and then followed up with this motion. And I've received no contact other than Mr. Krupp asking if I'd accept service for it.
All right, thank you. I
Your
think,
Honor, my client doesn't even know what system to contact to figure out to get a login, because he's not even allowed to know what system in the United States the children are involved in.
all right, we'll answer that right now. What healthcare system is it?
Zakkiya, can you say, I don't know the details. I'm sorry, Your Honor. That's a little too far down the details for me. You're muted.
I don't know the details.
So no, she's asking you what the healthcare system, like what system are you registered with the kids, your new. the
What
new
hospital system?
providers?
We're transitioning them into Medicaid here in Illinois, so we just had to cancel the Michigan Medicaid.
I'm not asking that. I'm asking what hospital system do you take the children to be treated at?
Lutheran General Hospital. I
Okay.
don't know. Maybe Epic. My mom said it's Epic.
No, Epic is the computer system. So Lutheran General Hospital in Chicago.
That's the only place we've gone.
Okay.
But they don't really have records there. The records Zachary was asking for were in Michigan, and I reminded him they're through Corewell Health, so he can contact
Okay.
them.
All right. Thank you. I'm going to mute you again. All right. First of all, to address the motion order to show cause, the court at this time is not going to find the defendant in contempt. The court would have to find a willful violation of this, and it's not, I think that would be a very difficult level of proof for this court to find that she's willfully violated the order by essentially walking into the room and turning the camera or instructing the children to turn the camera or whatever. So I will deny that order to show cause at this time, but I will indicate that the parties are to begin using our family wizard. There is, I believe, a virtual parenting time feature that's on there that can be used, and it will certainly eliminate or limit the amount of back and forth and accusations between the parties where there's no way to prove anything going forward. I will modify the order to require that the defendant ensure that the children know that those cameras are to be on them during parenting time, during their parenting time with their father. And I think that's it for that. That the defendant provide the health information in terms of the identity of the locations where the children are being treated. But then it's up, and again, that can be done through our family wizard. And then it's up to the plaintiff to follow through. He does have joint legal custody, and he should be able to, with that order, get into whatever he needs to get into, but that's going to be on him once that identifying information is provided. And as far as the fall school issue, I will refer that to the referee for an evidentiary hearing regarding choice of school.
I guess, Your Honor,
Yeah.
just get maybe.
The court does, hold
on.
on, the court does have a sort of a standard template for our family wizard that Ms. Van Noller would be happy to share with the attorneys so that they can tweak it to suit this case. And there is an option for asking that the fee be waived.
And I assume the 7 PM on Friday to 7 PM on Sunday is okay, an hour change to accommodate Chicago.
Ms. Wolfram,
I imagine it would be. I don't see any reason why I wouldn't. I didn't.
it
that
sounds
clear.
reasonable to me and makes sense.
Sure.
So,
And then as far as the school issue, Your Honor, I mean, we actually, we need some kind of a trial date. I was telling Ms. Wolfram in our discussions that obviously this case needs to come to an end at some point. So if we send it to a referee, I don't know if that's gonna really end the thing. It will probably just make the case go on more versus just having a
when was this filed?
November 2024, and we haven't really had a settlement conference date or a trial date or anything, and we're rolling into.
Oh, I wonder how that slipped through the cracks because it should have been one 6 months in.
I think because we did temporary orders, that I think perhaps we got off the record because of the temporary orders that were entered, but.
That shouldn't have mattered, but okay. All right. Well, let's give you a trial date because we are I think that the school issue is still going to need to be dealt with by the referee. That's a whole separate thing. And we're in July and school starts late August, so I don't know if she can even get you in, but
Well, unfortunately, I mean, the referee hearings I've been having, we get a 3-hour chunk. So I'm assuming it'll probably take a year to get I've been doing 3-hour chunk, 3 months later, 3-hour chunk, 3 months
Okay.
later. So
all right, but fine. I'm just saying I cannot get you in before school starts. So and generally the court does a status quo until educationally until there can be that can be addressed. So all right. Ms. Van Noller, can you give us a date for a trial? Probably
Can I
in
grab my book,
September?
Your Honor?
Sure.
Do you think we'll need a half day or a full day for this?
Counsel?
I can't imagine. We have almost no property to decide if there's there's one issue of maybe that outstanding debt from the apartment or the house that they rented. And then if the custody stuff is at the trial, I mean, I less than a half day, 2 hours at most if we're deciding the school issue separately. Because the parenting time is essentially already decided. I can't imagine we're gonna do something different. So
Okay, so let's do a half day.
yeah.
All right, so then we're looking at Monday, September 8th from 9 to noon.
I actually have a trial with Judge Gardner all day.
Then we could do Monday, September 22nd from 9:30 to noon or
That's
9:30 to 12:30.
Works for me.
Okay.
So
And then let's set a settlement conference. Let's set a settlement conference for a couple weeks prior to that, Ms. Van Noller.
All right, so then that would be September 4th at 2 p.m.
that works.
Okay. And Mr. Krupp, you were going to say something else?
Oh, I was just, so should we include in an order that the matter needs to be set for the referee to have a hearing on the school issue?
If you want, if you want it addressed before trial, but like I said, I doubt she can get you in, but so it's up to you.
Well, I guess I'm trying to understand what the court's saying, so I mean, I'm assuming that we need to address the issue. You're saying you need to go to the referees, have a hearing, and then do an appeal or settle it or whatever.
Well, we can just set it for, we'll just do it at trial. That's
Okay.
fine if it hasn't been resolved.
And then I assume that we can get school records from the defendant, et cetera. Because I don't want to hear, oh, Discovery's closed, so now you can't figure out what the school records are.
Okay, yeah, I was just about to say, I know what the scheduling order says, but I also know it appears this case kind of fell through the cracks, so.
And I have no problem with discovery. Keep it open to the day of trial, Your Honor. It's fine with me.
Okay.
Okay.
And again, I would expect that the council exchange whatever information is necessary for the court to make a decision if, in fact, that it's not resolved.
Indeed.
Okay.
Your Honor, I guess there would be one thing. I know that my client's resources are limited and she is located out of state now. Is her in-person appearance required for trial? Because it certainly would be a hardship. There's nobody in Chicago to watch the children, so.
I have done many Zoom trials.
Just
I
making
don't
sure.
have a problem with that. Anything else?
I think we're good, Your Honor.
All right, thank you. We're adjourned.